Hello friends, in the series on the income tax cases, today we will discuss an issue that whether the addition under section 69A can be done on the basis of some ad hoc percentage. Section 69A talks about unexplained money. In the present case, the CIT appeal has sustained the addition under section 69A at the rate of 10%, even when he was very convinced with the assessee that this cash deposit was from the explained activities of the assessee. So the question was that whether the addition on the ad hoc basis can be done under section 69A. This issue has been taken up by the Nagpur I.T.A in the case of Sanjivani, Mahila, Gramin, Bigar, Sheti, Sahakari Sanstha versus Income Tax Officer. This case is reported in 126 I.T.A Tribunal at page number 713 and the date of the judgment is 27th May 2025. The present case relates to the assessment year 2019-20. The assessee is a cooperative society which is registered under Maharashtra Cooperative Societies Act 1960. The assessment year is 1920. The assessee has first of all got a PAN number in the name of a firm, but when it realized that this PAN number is not justified for the assessee surrendered this PAN number on 26th June 2019 and applied for a fresh PAN number. But when this PAN number was officially surrendered by the assessee, the income tax department did not deactivate this PAN number and all the annual information report was going on the PAN number of the firm. During the financial year 18-19, which was relevant for the assessment year 19-20, there was some cash deposit which was from the activities of the assessee, and it was only through the pass-through entity the assessing officer got the information, and on the basis of that information on the old PAN number which was not deactivated by the assessing officer even after the request of the assessee, the assessing officer issued the notice under section 148 to the assessee on the old PAN number. During the assessment proceedings, the assessee explained all the facts, but the assessing officer made the addition under section 69A for undisclosed cash deposit and undisclosed interest income. Because the assessee was not filing the return on the old PAN number which was in the name of the firm and which was surrendered, the assessee explained that this information has been duly taken care of in the return which has been filed by the assessee as a society, but the assessing officer made the addition. When the matter came before the CIT appeal, the CIT appeal accepted the explanation of the assessee in principle, but the learned CIT appeal sustained the addition on the ad hoc basis of 10% of the cash deposited. The assessee further filed the appeal before the Honorable Tribunal, and when the Tribunal heard the matter, the Tribunal was first of all of the very considered view that if the explanation is found correct substantially and not disproved by the assessing officer, then in that case no addition could have been made under section 69A. Further, the Tribunal was of the view that there is no scope of ad hoc addition for quantification of deemed income because it is a fact specific. The meaning thereby that once the assessing authorities accepts the concept of cash deposit of the assessee substantially, then there is no scope of any ad hoc addition under section 69A. So the Tribunal deleted the addition of 10% also. Friends, this case is very important because deeming provisions are very strict. The deeming provisions cannot be stretched by the department for making ad hoc additions. They are very fact specific. Once the revenue accepts the contentions of the assessee in principle, so no ad hoc addition should have been made. At the end of this video, once again I am repeating the name of the case. The name of the case is Sanjivani, Mahila, Gramin, Bigar, Sheti, Sahakari Sanstha versus Income Tax Officer, and this case is reported in 126 I.T.A. Tribunal at page number 713, and the date of the judgment is 27th May 2025. Thank you, friends.